All right. It looks like some people are still logging in, but I will go ahead and get started. So thank you all for joining JMT Consulting today for our webinar, Avoiding Costly Legal Mistakes When Reopening Workplaces During the Pandemic. My name is Kim Perlman, and I'll be your moderator throughout today's webinar, and I'm excited to be hosting this session for you all today. This webinar will be led by Lisa Brauner, and I will properly introduce her to you all in just a moment. Today's webinar is brought to you by JMT Consulting. We are ERP and financial management solution specialists for nonprofits. We have nearly 30 years of experience helping nonprofits with technology and business processes for the back office. Before we get started today, I'm going to cover a few housekeeping notes. First, we are recording today's webinar and we'll email it to you within 24 hours along with the slide deck. We'd also love to hear from you during today's presentation. If you have a question for Lisa, please send it through the Q&A tab at the bottom of your screen. We will have a dedicated Q&A session at the end of the webinar where Lisa will answer any questions that have been submitted, so please don't be shy. Next, I wanted to give a brief disclaimer that this webinar is provided by Lisa for you all, but is meant for general information purposes only and does not constitute legal or professional advice. We will provide Lisa's contact information to you all if you would like to speak with her outside of the webinar for a legal consultation. Finally, I would like to introduce Lisa. She is an employment law partner with the law firm Perlman Perlman based out of New York City. Perlman Perlman is dedicated to serving the social sector and works primarily with nonprofit organizations. Lisa focuses on employment law, specifically advising and representing employers in workplace law-related matters. Lisa attended Tufts University and got her JD from Brooklyn Law School, and she's been making a name for herself in the employment law space ever since. Since 2014, she's been selected to Super Lawyers every year. Super Lawyers is a peer designation and only awarded to a select number of attorneys in each state. Naturally, we are excited that Lisa is joining JMT Consulting today to share her knowledge and expertise with you on this timely topic. So with that, we'll kick things off by welcoming Lisa. And Lisa, over to you now.
Thank you, Kim. I'm delighted to be with JMT Consulting and to be with all of you today on this ever-timely topic and ever-changing issue on reopening the workplace. So things have changed pretty rapidly, and as you all know, some of you may have already reopened. Some of you may have started to reopen and then closed again. So I know that the situation for each of you will be different. And this is general information I'm providing, not legal advice. I can't give legal advice with respect to any particular situation, but this is really general information for you to have a sense of some of the legal issues that arise both during the pandemic generally and things to think about as you reopen the workplace to avoid making costly legal mistakes. So we're going to really cover 3 areas today, which is just a general discussion about pre-planning for reopening. We won't go into specifics on each of the things that you need to think about because each nonprofit organization is different, both in terms of who it serves and its physical layout. So the types of things that you need to do need to be customized to whatever your workplace is and the type of organization that you have and who your clients are, who you are servicing. So, but there are some general rules that you want to keep in mind. So we're going to go into that, and then some potential workplace legal risks and ways that you may help to mitigate those risks. So in terms of thinking about reopening, for those of you who haven't reopened yet, this is a great time for you to be planning, even if you don't know exactly when your office will reopen or your workspace will reopen. It's great that you're on this webinar and thinking about what are the considerations I should be I should be thinking about. So the Centers for Disease Control has put forth, you may have seen, some guidance for businesses reopening, and some of the things it said is in terms of should you consider reopening the workplace. First of all, obviously, your decision to reopen has to be consistent with what your state and locality allow. Have they issued an order allowing you to reopen? Are you in the phase that your state is allowing you to reopen? And if the answer to that is yes, then the next question is, are you ready to protect your employees who are at a higher risk of severe illness? And if the answer to that is no, then you don't reopen. If you cannot safely reopen your workplace, then you don't reopen at this time. Number two, are recommended health and safety actions in place? If the answer to that is no, then you don't reopen at this time. And the third question is ongoing monitoring in place? Do you have a mechanism to monitor your safety and health protocols? Do you have measures to address if someone in your workplace gets ill with COVID-19, how you're going to go about handling that, how you're going to isolate that person, how you're going to notify others who may have been exposed, how you're going to do monitor and do contact tracing? Do you have someone, once you've put your safety protocols in place, do you have a way to enforce those protocols? So those are things that are important. And as I had mentioned earlier, there's not a one size fits all when you're reopening because every nonprofit organization is different. So the plan that you create is going to be specific to your workforce and also your workspace. And what I can say kind of universally, regardless of the type of nonprofit that you are, is that you're going to want to do a risk assessment. You're going to look at every job that you have in your organization, and you're going to look at every area, every job task, and every physical aspect of your workspace to identify what are potential exposures to COVID-19. And then your plan will include measures to eliminate and reduce the exposure to COVID-19, including measures for isolating and identifying and isolating someone who is ill with COVID-19. Your plan will have a means to monitor ongoing cleaning and disinfecting, and also social distancing measures. And I would recommend that you're adhering to CDC guidance of OSHA, which is Occupational Safety and Health Administration. That's a federal agency that governs safety and health in the workplace, and that you also adhere to whatever your local guidance or orders are. Some states have issued orders about certain things that you need to do. For instance, in New York, a business that plans to reopen has to both create a safety plan, and the governor has issued a template for that. They have to issue that. They should provide that to their employees, and businesses have to actually submit a written affirmation that they have read the state's reopening guidelines and they're going to adhere to them. So your state may have particular orders that need to be complied with before you're allowed to reopen. Think about, if you haven't designated a COVID-19 task force, that you do designate one to address these issues, and that you are providing cloth face coverings to your employees, to people that come on premises. In some states, it's mandated for employers to do this. In other states, it's not. But as a risk mitigation measure, even if it's not required, that's something that you are going to want to consider, that you're providing that. And communicate frequently with your employees, more so than you ordinarily would. Even if you're not planning to reopen right now, just to stay in touch with your employees to let them know what the update is, what the plan is. So I want to just get a sense from the audience today. I know we have over 100 people registered today, and want to have a sense of those of you on the call today. How many of you have actually formed a task force in your organization to plan and strategize your return to work? And if you would just answer that question, your poll question, that would be great. And then we'll share the answers with everyone.
Yep, you should have seen this poll question pop up on your screen. Looks like 74% of you all have voted. And Lisa, right now, yes is the leading answer with
Okay, well, that's
28 votes.
fantastic. Okay. All right. So
And
that's,
we'll just give it a few more seconds and then I can share the results with you and everyone can see. Okay, I'm going to end the poll and share results. Can you see that?
okay. Yeah, so 74% said yes, 26% no. So most of you have formed one, and the rest of you are thinking about your next steps, which hopefully will include, you're going to have this task force who's not only going to create your safety plans, your social distancing plans, and implement them and communicate them to your employees before they come back to work, but will also be monitoring how those are working and whether they're being enforced. If you have a policy that your employees need to wear masks, but people are wearing them around their chin, that's not going to work even though you have a nice looking plan in place. So it's important that you implement plans assessing risk, but also that you have a means to enforce those. So the next poll question is, have you created safety protocols for return to work? So if you would answer that question as to kind of where you are in the process here. Yes, no, or you're working on it.
Okay, I have just launched the second poll. You guys vote quickly, thank you. Okay, I'll just give it another 10 seconds or so, and then I will share the results again. Looks like 40 people submitted a vote. And go, share results.
Okay, 63% have said yes, 32% are working on it, and 5% no. So that's great. And the majority of you have already put in place your safety plan, and others are a lot of you are working on it now, which is great. So some of the other things that you're going to be thinking about before you reopen, obviously, are not just your safety and your health plan, but and how you're safely going to bring employees back, but how you're going to staff coming back. How are you going to do it? Are you going to have a phased approach for employees to come in? A lot of employers are doing a situation where they're bringing different groups of employees back on different days. So maybe you decide you're going to stagger the start times for your employees so they're not there during rush hour, or you're going to have employees working on alternate days, or modifying their schedule so that you are reducing the density of employees in your workplace at one time. You may consider, actually, we're going to be continuing to work remotely, and just kind of have a skeleton crew of people that are going in as needed, but we're going to all continue to work remotely for the foreseeable future. And if your employees can continue working productively remotely, depending on what the situation is in your particular jurisdiction, that may be the safest thing for now. So consider whether your employees can continue working remotely. And we're going to talk about a little bit later on some legal risks for you to be thinking about as your employees continue to work remotely, particularly as if they're working remotely now over a longer term. So you're thinking about who's going to work remotely, who needs to go back into the office, if anyone needs to go back into the office, and whether in fact remote work might be a more long-term solution for you at your workplace, or if you have multiple workplaces, maybe there's certain workplaces where that's going to be the best solution for you. And finally, our last poll, I want to get a sense from you about the types of employee claims that you're most concerned about. So if you would answer that poll question, that would be great. Reasonable accommodation issues, disability discrimination issues, issues around safety, OSHA or workers' compensation, the National Labor Relations Act issues and union organizing, Family Medical Leave Act, the Emergency Paid Sick Leave, Emergency Paid Family Leave laws under the Families First Coronavirus Response Act, claims of discrimination, harassment, and retaliation, wage and hour issues, WARN notices. We can talk a little bit more about that later. Cybersecurity issues, employee privacy, or if there's something else that's not on this list that's really your primary concern, let me know that. And if you have multiple, there are multiple issues, you can check more than one box too.
Mm-hmm. Unfortunately, our polling doesn't allow you to write in, but
okay.
if you have if you have an other that you would like to share with Lisa, you can just drop it in the chat, and that would work as well.
Okay.
It looks like we have 72% of the votes in, so I'll give it another 10 seconds or so, and then we can share it. But so far, okay, Nate says mental health and social accommodation for her other. I'm sorry about that. And I'm going to go end poll and share results. There you go.
Okay, so we have, I'm just taking a look here. It's interesting that the largest percentage of concerns are evenly split between safety, OSHA concerns, workers' comp, and FMLA, leaves of absence, emergency paid leave, and those kinds of concerns. Those seem to be the two greatest areas of concern, followed by reasonable accommodation issues. And that's consistent really with what I've seen throughout with clients, is that the safety concerns weigh most heavily in terms of employee concerns, and rightly so. And it's the reason why I started off my presentation really talking about some kind of overarching issues that you need to be thinking about to create a safe workplace for your employees. We're going to talk about a little bit more about OSHA, about those kinds of claims, as well as claims around paid leave laws, because I know that those are really big concerns. And I want to also just talk about some of the common questions that I've been receiving. And one of those, which also gets into safety issues, is what if my employee refuses to return to work? What if they say, I don't want to come back? Well, my response is that you as the employer will ask them, well, what's the reason you're refusing to return to work? Because that will govern how you're going to respond and whether they might have certain legal rights in connection with that. So maybe your employee says, I'm not going to return to work because let's say you had somebody on, somebody on furlough, and they say, I'm earning more on unemployment insurance. Well, I'm getting the extra $600 a week. That ends at the end of July. And in many states, the person has to be ready, willing, and able to work. So that is not, depending on the state, that may not be an acceptable excuse for them not to come back if you have work for them and they've been furloughed, but now you're ready to take them back. But what if your employee says, I have an underlying medical condition that puts me at heightened risk of contracting COVID-19? Well, then that's maybe a different conversation that you're having with them. Because under the law, under federal law, and under many state and local laws, employers have a legal obligation to reasonably accommodate an employee's disability. That could be a physical disability. It could also be a mental disability. If somebody has, under the Americans with Disabilities Act, which covers employers with 15 or more employees, an employer has to engage in a good faith interactive process with an employee to determine a reasonable accommodation that allows that person to perform the essential functions of the job. So it could be a physical condition, it could be some type of mental condition, like if somebody had PTSD, or they have a severe anxiety or clinical depression. There could be also mental conditions that would qualify, that might qualify as a disability. So that's a determination you'll need to make, whether the condition qualifies as a disability, and if so, then you have a legal obligation to reasonably accommodate. And I can tell you in New York, for instance, the EEOC, which is it's a federal agency that enforces the Americans with Disabilities Act, they have said that the highest number of cases that they're receiving, the regional office in New York, are these types of a failure to reasonably accommodate claims. So that's something to be aware of and alert to. And you want to make sure you're engaging in that interactive process, because failure to do so could result in legal liability to you. Also, just be aware that your state or locality may impose even greater obligations on you than just engaging in an interactive process. So for instance, in New York City, employers have to engage in what's called a cooperative dialogue. They don't have to wait for the employee to request a reasonable accommodation. They may need to proactively engage in that conversation where they know that the person has an underlying medical condition. In New York City, they have to document the request and their response, whether they granted or denied it. So it's a much more involved process, and depending on the state or locality that you're in, you may have greater obligations of what you need to do when an employee has an underlying medical condition. You also want to be on the alert for potential discrimination claims. You cannot prohibit an employee who has an underlying medical condition, who's pregnant, or who's an older worker. You can't bar them or prohibit them from coming back to the workplace simply because you have a fear that they may contract COVID-19. That would be considered unlawful discrimination. And the laws, the Americans with Disabilities Act and state and local laws often will prohibit retaliation against a person for requesting a reasonable accommodation. So it's really important to be aware of retaliation claims, and a way to mitigate those is to ensure your managers are properly trained on what the law is and that retaliation is prohibited. Because retaliation sometimes, those types of claims, those are actually the largest category of claims that's filed with the EEOC are retaliation claims. And oftentimes a discrimination claim comes with a retaliation claim. So it's particularly important that you are educating your managers and training them about what retaliation is and the prohibition on that. That's a key thing that you need to do, as well as documenting any requests for reasonable accommodation and what your response to them was. So, it may be that an employee with an underlying health condition or pregnancy requests to work remotely as a reasonable accommodation. That may not be the only accommodation. You may be able to set things up in your workspace that creates a sufficient social distance to keep that employee safe, whether it's putting a plexiglass divider or reconfiguring your workspace in such a way to allow for social distance so that the person with the underlying health condition's exposure to it is minimized. But be flexible and be creative in coming up with solutions to provide reasonable accommodations to those employees. I know I've also gotten questions about in urban areas where employees are taking mass transit and have fears or concerns about traveling. The question that I've gotten as well, what's the employer's obligation with respect to that? Well, the person's not at the workplace, so their obligation doesn't necessarily extend to how that person travels to work, but employers come up with all kinds of creative solutions about how to get their employees to the workplace. You may be in a situation where you're able to provide transportation to employees or allow them to be able to take private cars and things like that, or provide group transportation in a way that still allows social distancing. So I think the idea is really to be flexible and creative in how you can support your employees to feel safe in coming to the workplace. And we talked about that disabilities can be both physical and mental or psychological conditions as well. The other thing to think about is, do you have employees who are working remotely who have a medical condition who might need to be reasonably accommodated in their home workspace, whether it's something that they need ergonomically, whether it's something else. So that's something to consider as well. Are there reasonable accommodations? Because even though that person's working from home, your responsibility as the employer to reasonably accommodate them so they can perform the essential functions of the job where they have a disability remains the same, even though they're not in your physical workspace. You may have situations with someone that you know, an employee who currently has a disability, and you need to make certain reasonable accommodations for them. So I give the example of, you have an employee with low sight, and you've now decided you are reconfiguring your workspace. You're going to have one-way hallways. You're going to have markers on the floors that indicate 6 feet of distance. Is your low sight employee going to be able to see these things, navigate around your reconfiguration? And so you want to be thinking about these things before you're bringing the employees back. And you want to share your safety plans with the employees before you bring them back. You know, have conversations with them about what your plans are. If you have an employee who's hard of hearing and they lip read, you have to think about, if you're providing cloth face coverings, what kind of modifications you may need so that they can perform the essential functions of the job. So ways to mitigate risk with respect to these kinds of claims, disability discrimination, failure to reasonably accommodate, is just make sure that you know what the EEOC's guidance are and what your state and local laws are, as well as the guidance that's being issued by the various agencies. These agencies are updating their guidance as the situation evolves. So you want to stay up to date on what those changes are and what kind of guidance they're issuing around what the laws. Be flexible and creative in coming up with accommodations, and documenting your efforts to reasonably accommodate your employees also helps to mitigate risk. So there is an undue hardship defense. Let me just go back for a second. If an employee requests a reasonable accommodation under the Americans with Disabilities Act and other state or local laws, an employer may be able to respond affirmatively. Providing a reasonable accommodation would pose an undue hardship on our organization, but that has to be, you have to document the basis for that, and maybe a high threshold to establish that. So my suggestion is that you do your best to work with employees to find a reasonable accommodation that allows them to perform the essential functions of the job, as long as it isn't posing an undue hardship. And be careful about preconceived notions or assumptions about whether someone is unable to do the job because you might have a claim of perceived disability discrimination. So that's important to be aware of. Another place where employers can get into trouble around the issue of reopening is with respect to health screening. One aspect of your safety plan in bringing employees safely back into the workplace is screening your employees before they step foot into your office to make sure that they don't have COVID-19. So whether it's doing a temperature check, whether it's providing questionnaires to employees about whether they're exhibiting symptoms of COVID-19, which you may ask now because we're in a pandemic. The EEOC has given employers the green light to do things like take temperature, which ordinarily you would not be able to do unless it was job related and consistent with business necessity, because the EOC considers that to be a medical examination, as well as, you know, asking questions about symptoms of COVID-19. So, so those things you can do. You can take, you know, have them take COVID-19 tests. Those things that you can do. What you cannot do, what you may not do under the Americans with Disabilities Act, is you may not prohibit them from coming to the workplace unless they've had an antibody test. That the EEOC says no. Under the Americans with Disabilities Act, you can't require your employees to take an antibody test. Antibody test is not a test for COVID-19, so that's not permissible. The other thing that's really important is that these types of things, the health screening things, whether it's taking the temperature, conducting a test, doing a questionnaire to ask about symptoms, all of those things are considered medical exams. And under the Americans with Disabilities Act, you have an obligation to keep those records and that information confidential. That means you're keeping the results of it. If you are recording temperatures, which you may or may not decide to do, you might decide we're not going to record the temperatures. What we're going to do is we're just going to indicate if this person has a temperature over 100.4, we're going to note that, we're going to send them home. If they have a temperature below 100.4, then they can come into the workplace. But you may not, let's say you may not be keeping a log of who has what temperature. So you might, that's going to be up to you whether you're going to record the temperatures or not. But if you are recording the temperatures and you now have a record, that information has to be kept confidential. It cannot be kept in an employee's personnel file. It should be kept locked and limited to only those with a need to know. One of the common questions I get is, well, what happens if an employee in our workplace develops COVID-19? Are we allowed to tell other employees that this employee has COVID-19? And the answer to that question is no. Under the Americans with Disabilities Act, that information, the identity of the person, it may not be disclosed to other employees. What you may do is and should do, and in some instances must do, is tell your employees if they've been exposed to someone that you know has it. You need to let them know that. And you may also, but you just can't disclose the identity of the employee who has COVID-19 to other employees. You may disclose, and in some instances you may have to disclose the identity of that employee to state or local public health authorities. And what's the reason for that? It's so that they can conduct contact tracing to make sure that they are containing the spread of COVID-19. So I hope that that information is clear. So the issue of confidentiality is very important. So now let's get into what is really a primary concern for many of you, which is the safety concern. So under the Occupational Safety and Health Act, which is enforced by the Occupational Safety and Health Administration, which is a federal agency under the U.S. Department of Labor. Anyway, under that law, OSHA, employers have a general duty to provide a workplace that's free from recognized hazards that are causing or likely to cause death or serious physical harm to employees. And the law also prohibits employers from retaliating against employees for exercising their rights under OSHA, including complaining about health or safety to OSHA. Why am I mentioning retaliation? Because again, retaliation is really a big issue where employers get in trouble, where somebody makes a safety complaint to OSHA and then the employer retaliates against the employee. While employees may not bring a lawsuit under OSHA, the Secretary of Labor can issue citations and very steep penalties against employers that violate OSHA. And the penalties get even steeper where there are repeat violations by an employer. So You do not want OSHA complaints in your workplace, and you want to do everything that you can to mitigate that risk by having a mechanism where employees can raise safety and health concerns to you. So if you've got a COVID-19 task force that you've created or you will be creating, make sure that that task force has created a policy. You have a policy in your handbook, you've updated a policy on safety and health issues and who the point person is for employees to go to if they want to raise a safety concern. Let's say you've implemented a policy that everyone in the workplace must wear a mask, except maybe if they're sitting in their own workspace. And that policy, it turns out, is not being enforced. Employees are not wearing their masks, or instead of covering their nose and mouth, they're wearing it around their chin. And an employee is concerned for their own safety and whether they might contract COVID-19 from a coworker. If they don't know who they can raise their concern to, they may end up going to OSHA. So you want to make sure that you are nipping the issue in the bud and that you have a way for your employees to be heard where they're concerned. Even though I've said to you that employees don't have a private right of action where they may not go to court for an OSHA violation, we have heard reported that there has been litigation over safety issues. Oh, and I should also mention that your state may also have its own mini OSHA law. So it may have, you have to be aware of not just the federal law, but that your state may have some laws about governing safety issues in the workplace. So just be mindful of that too. There has been litigation, there is litigation. I have an article that I've written about kind of a counterpart to the webinar today, which I'll be making available, which goes into a lot more detail about some of these cases. But essentially, there have been a bunch of McDonald's franchises that have been sued by workers, alleging a variety of different things, like either that the entity didn't provide proper didn't provide masks or provided dog diapers and coffee filters as masks, didn't enforce social distancing, or the social distancing policy it enforced didn't comply with the law. For instance, there was a franchise in the Chicago area, and that particular franchise said that employees didn't need to didn't need to wear a mask if they were less than 6 feet from another employee, as long as their interaction was less than 10 minutes. It was something to that effect, which was in contravention of what the governor of Illinois had ordered with respect to social distancing. So there has been litigation, and so you may say, well, what kind of litigation? What was the allegation? The allegation was they came up with a novel theory saying that their employer had created a public nuisance. And so far in those cases in Illinois, the judges have ruled in their favor, essentially shutting down the business until proper social distancing was in place to protect the employees. So there is a risk of that, plus beyond the legal risk of having your organization's operations shut down, there's a reputational risk. No organization wants to be on the front page of a publication or in the news about not protecting its workers, or not acting in compliance with what the government has said an employer needs to be doing to keep its workers safe. So there's that litigation. There's also another lawsuit by Walmart. The family of a Walmart employee brought a wrongful death action against Walmart on behalf of their family member who was an employee at Walmart, along the lines of, that the employer did not created an unsafe condition or did not create the social distancing and provide face coverings and other things that are needed to keep the employee safe. That's the allegation. We don't know the outcome of that case at this time. OSHA has also issued guidance recently. They've They have a lengthy pamphlet reopening the workplace and different safety measures that employers can take to when reopening the workplace. So I recommend taking a look at what that guidance is. They've also issued guidance indicating that certain employers need to report COVID-19 illnesses that occur in the workplace, where those are job-related. So that's also something important to take a look at as well. Not all organizations are covered by this reporting obligation, but they have issued guidance saying that in certain circumstances, those illnesses that arise, those illnesses in the workplace may need to be reported. So we talked about that the Secretary of Labor can bring a legal action as well. I mean, they can issue citations, but also bring a legal action, even though employees themselves can't bring that legal action. And an OSHA retaliation claim might form the basis of a state whistleblower action. You might be in a jurisdiction that has a whistleblower law, and that whistleblower law might cover the reporting of safety or health issues in the workplace. So that's something important to be aware of as well, that there could be state whistleblower laws that protect employees who speak out. So another area of potential risk is even for those workplaces that do not have unionized workforce, non-union workers have rights under the National Labor Relations Act. They have the right to form union. They have the right to engage in what's called concerted activity, to act as a group, to speak up about terms and conditions of employment. They can complain about their wages collectively. They can complain about safety and health issues and be protected under that law from retaliation for having done so as a group. Concerted activity is usually 2 or more people acting together. I would anticipate that there may be an increase in union organizing activities at workplaces that are non-union as well. Why? Because safety and health issues are often a rallying cry of unions. This is where they get involved. If employees feel that they don't have a place to go to have their grievance heard, they may turn to a union. And unions, are certainly looking to expand, increase their dues at a time of high unemployment, or they may have fewer members. This may be an opportunity to increase that activity. So if you're a non-union workplace, this is something to be mindful of and ensure that as I said, your employees that you have policies in place addressing safety and health, and that you have a mechanism for employees to raise concerns about safety and health. We've heard in reports in the news about workers at Amazon and other places, holding sick outs, leaving the facility saying, we feel our employer is not providing a safe workspace for us during this pandemic, or in the situation of the McDonald's workers going on strike and saying, we don't feel safe coming to work. And the, group activity, a refusal to return to work due to good faith safety concerns could be legally protected activity. So what is concerted activity? It's where it's being engaged in typically with other employees and not solely on behalf of the employee themselves. Retaliation for participating in a sick out, that could be protected activity under the National Labor Relations Act. So that's important. So how do you mitigate these risks? I know that these safety risks are a big concern for you, and you do have ways to address it. You do have ways to mitigate the risk. And, it's having a mechanism for employees to raise these concerns. It's having policies addressing safety. It's having the safety protocol. Even if it's not mandated by your state that you have a safety plan, put one in place, share it with your employees, let them know what you're going to do to keep them safe. Follow the guidance of the CDC and your state and local guidance, particularly where that guidance is even more protective than what the CDC is recommending. Review OSHA's guidance and follow OSHA's guidance, implement that and as part of your safety plan. Document the measures that you're taking to to clean and disinfect. In some jurisdictions, you might be required to keep a log of what, of your efforts to disinfect and clean the workplace. Document your safety measures. Create, to the extent you can, low touch in your workplace. So what do I mean by that? If there's a way to keep the door open so people don't have to touch it as much. If people have to sign in by putting their hand on a scanning device, maybe there's some alternate way that you can, during this time, find a way for them to sign in. Think about your different work areas and how you can make those low touch. Have hand sanitizing stations. Think about whether you're going to provide, shoe covers for employees coming in, so not tracking the virus, that you're going to provide not just hand sanitizing stations, but you'll have Lysol wipes, you'll have face coverings, maybe gloves you'll have. Think about if you've got a kitchen area, how you're going to make that low touch, whether you're going to be using, paper plates and plastic utensils. You think about each area of your workspace and how you're going to make it low touch, what you're going to communicate to your clients about not just when you're reopening, but how you expect their interactions with your staff. So you really want to think about each area, as I said at the beginning, do a risk assessment and what the potential exposure is, and each job, task, and responsibility. You have employees going out to the field. How are you going to keep those employees safe? What measures have you put in place to keep those employees safe and to maintain social distance? And what are you messaging and communicating to your clients about how you expect those interactions with your staff to be engaged in? So we talked about that, an effective mechanism for employees to raise concerns. Document your efforts to address those concerns. That's really important too. Workers' compensation claims. I just raised that, it's different in every state what the workers' compensation laws are. While we think about that, workers' compensation is generally the exclusive remedy for employees for a type of negligence claim. If an employee were to get sick on the job, become ill on the job, it's unclear whether workers' comp is going to cover COVID-related claims in each instance. I mean, we do see in some states that they've changed their workers' comp laws to provide a presumption that workers' comp would cover COVID-19 in, let's say, healthcare industries. But whether workers' comp will cover such a claim, a COVID-19 claim in the workplace, is going to depend on your state's workers' compensation laws. And you know what? There could be liability for employers. That's the other question, right? The $10 million question is, can we be sued by our employee if they get COVID-19 in the workplace? There's not a clear answer to that. I will say that you may have heard in your own state or other states that are enacting or have enacted business immunity laws. Georgia just recently enacted a law that would provide immunity to businesses against claims by employees, by clients and others, some type of limited immunity for claims relating to COVID-19, except if the conduct of the business is grossly negligent or reckless, that the law hasn't yet been signed by the governor, but is expected to. In other jurisdictions, some other jurisdictions have also enacted some types of immunities for certain types of organizations, doctors and hospitals and other kinds of healthcare organizations. So right now it's limited. There have been calls at the federal level by certain representatives in Congress to provide a business immunity in the next COVID-19 legislation. That hasn't happened yet, but it has been proposed. Another area of concern I know addressed by you is the issue of, or that you've mentioned, are the issues of the paid leave laws. So you might remember, we're not going to go into great depth on this, but you might remember that the Families First Coronavirus Response Act was passed earlier this year, a federal law that applies to employers with fewer than 500 employees. And it provides both paid sick leave benefits and an expansion of the FMLA. FMLA benefits 12 weeks of paid family leave, and that the law is in effect until December 31st of this year. So where are the potential legal risks around this? Well, we'll discuss it in a few different ways. First, there's something called the small business exception. So employers with fewer than 50 employees can elect to be exempt from providing paid sick leave or family leave if the paid sick leave is to care for a child whose school or childcare is closed due to COVID-19. So this exception applies only if that leave would jeopardize the viability of the business. And it only relates with respect to the paid sick leave is if that paid sick leave is being taken to care for a child whose school or childcare is closed due to COVID. And employers that are invoking this exception, the small business exception, have to document various things to an officer of the organization to demonstrate that it would in fact jeopardize the viability of the business to provide that leave. So where employers could get into trouble is, number one, they fail to provide the leave required under the FFCRA, whether either paid sick leave or paid family leave, or they misuse the small business exception. They don't really qualify for that exception, or they've used it improperly, or they can't demonstrate that providing the leave would jeopardize the viability of the business, or they improperly apply it with other types of paid leave. Your state or your locality may also have some type of emergency paid COVID-19 leave. So you need to look at what your state and locality has as well when thinking about this leave. You should have policies addressing these types of leave and the interaction with your own organization, paid leave, and issues relating to the FMLA, where you're an employer that's got 50 or more employees. So those are some of the potential legal issues, I think, to help mitigate it. Make sure that you have a policy on it. Make sure you train your managers about your employees' rights under these laws to take leave. One of the questions that I get is, well, school's closed now, so what about that? It's the summertime. I mean, can people still take the paid family leave if they can't get childcare? Well, again, it's going to depend on if your kid was supposed to go to summer camp, and that summer camp is closed now due to COVID-19, and you cannot get childcare, and you meet the other qualifying factors under the law, then yes, your employee may be entitled to that leave. The U.S. Department of Labor has issued guidance about that, specifically because here we are in the summer, and so the situation is different. Even though school's closed, there may be issues related to summer camp, depending on if that camp specifically closed due to COVID-19. So something to just be alert to. That law, the FFCRA, prohibits employers from retaliating against or discriminating against employees because they take this job protected leave. You can be subject to different damages and penalties for violation of either of these laws, either the Emergency Paid Sick Leave or the Emergency Family Leave Extension Act, or civil penalties or potentially the loss of the payroll tax credit. So I mentioned, I think two of the key things to do to mitigate legal risk is have policies that address these types of leaves. Make sure if you are invoking the small business exception that you're documenting the basis for that, and that you're training your managers on what employees' rights are, and to ensure there's no retaliation. Be aware of local laws with respect to this, and implement policies. So some of the other legal issues that we have around staffing are, deciding which employees you're going to recall to work and which employees you're going to allow to work remotely, who you're going to be furloughing, who you're laying off if you're doing layoffs, and how are you making those decisions. And it's really important that those kinds of decisions are being made, that you are probing the bases for these decisions with your managers to ensure that there are legitimate, non-discriminatory reasons for what you're doing. If you're recalling people because operationally you have to fill certain spots, then document the reason that you're doing that. If you're doing the legal risk are really discrimination claims. Someone saying, you chose that person you allowed them to work remotely because of X, Y, or Z. I think that you were treating me less favorably because of my gender, because of my race, because of my religion, etc. So you really need to make sure that you have legitimate non-discriminatory reasons, business-related reasons, that you are documenting the reasons for those, and that you're being consistent and fair. Don't allow favoritism or the fact that you're feeling sorry for somebody's personal situation to guide what need to be business decisions, or you will potentially face claims of unlawful discrimination. Same thing with respect to if you're doing salary cuts. Don't cherry pick who's going to get salary cuts and who's not. Have a consistent and a uniform approach. Maybe you're deciding employees earning above a certain level are going to get X percentage of salary reduction. Employees in the next tier are going to get Y percentage salary deduction, and the employees in the Z tier are going to get another percentage salary deduction. And that's a way that you can help to minimize the risk of legal claims. If you're doing a layoff, let's say, you want to look at, does this have a disproportionate negative impact on a particular legally protected group? Does it look like when we're doing this layoff that we're picking mostly women, or we're picking mostly older people, or we're picking people of a certain race? Even if that wasn't the intention, when we look at how this all plays out, when we look at this, we see that it is having a disproportionately negative impact on a particular legally protected group. You want to look at that, because you could have a discrimination claim if that's the case. So you need to consider the impact of the staffing changes, salary reductions, etc. Also, if we're doing salary reductions and we have a pay equity issue, we have women that are making less than their male counterparts, that situation, your pay equity situation, may be exacerbated by salary reductions. If you're doing if you're doing furlough, you may consider, when we recall people, we're going to address this pay equity issue. But just be aware that a salary reduction or salary reductions could exacerbate a pay equity situation that you may already have. And if you haven't done a pay equity analysis, generally speaking, that is something that you're going to want to do. You're going to look and see that men and women are making, are earning the same for the same job. You may also have a situation where now that if you are downsizing, restructuring, whatever the case may be, combining functions, you're going to want to update your job descriptions to reflect these new roles for a variety of reasons. One is you want to make sure if you have someone who you've classified as exempt from getting overtime pay, that person stays exempt. I mean, that's an important thing also with respect to salary reductions. You need to, we'll talk about that in a minute after we get past the discrimination discussion. So be consistent and fair in your application of decisions to avoid discrimination claims. Use neutral criteria, make sure that you can document the legitimate non-discriminatory business reason for the decisions that you're making, and your neutral basis for salary reductions. Another type of potential discrimination claims are, the EEOC has noted that there's been a rise in claims, discrimination claims, harassment of Asian employees with the COVID-19 originating in Wuhan, China. And so you want to make sure that you are doing your harassment prevention trainings regularly, that your managers are alert to issues that come up if derogatory comments or remarks are made, training your managers on how they're supposed to handle those situations, and ensuring that no one is retaliated against for raising concerns about being harassed because of their national origin, ancestry, etc. Okay, so just to kind of recap, make sure you're documenting whatever the legitimate reasons for any decisions that you're making, and be consistent in your decisions, so that to mitigate a risk of a discrimination claim, and make sure you're complying with all the guidance by the EEOC and your state and local anti-discrimination agencies. So getting back to furloughs and salary reductions, etc. Non-exempt employees you can't reduce their pay below the minimum wage. You have to be mindful of state or local minimum wage that may be higher than the federal minimum wage. Certain states have particular notification requirements before you change somebody's pay, so you need to know the jurisdiction that your employee is working in, and what obligations you may have with respect to notification or other things before you change their pay. Exempt employees have to be paid the full pay for any work week in which they do work, even if it's 1 day a week. And you want to make sure that if you are reducing the weekly salary of an exempt employee, it's not about the hours they're working, you're doing a salary reduction. As I said, it's not about the hours, because exempt employees don't get paid by the hour. They have a predetermined amount that they're getting paid each week. So you want to make sure that that amount does not fall below the salary threshold required to keep them exempt. So as you probably know, in order for an employee to be exempt from overtime pay laws, they have to meet a certain salary level, and they have to perform certain duties. If they fall below that salary threshold, the federal salary threshold, and sometimes your state has an even higher, the federal salary threshold is $684 a week, but your state may have its own salary threshold for someone to be exempt under your state's wage and hour laws. So if that person falls below the salary threshold because you've reduced their salary because you're going through a hard time, you may have inadvertently converted them from exempt to non-exempt, and will have to pay overtime if they work more than 40 hours in a week. So you want to be careful about that. But in addition to meeting the salary threshold, making sure they're still meeting the salary threshold, even with a salary reduction, you also need to make sure they're continuing to perform exempt functions, that's what they're doing primarily. As I mentioned, one of the risks here is, as organizations, I see, a lot of organizations they're going through restructuring, they're reconfiguring jobs, combining functions. You want to make sure that if that's happening, that the person who's exempt is still primarily, that they are performing exempt functions, and that they're not doing primarily non-exempt functions and inadvertently converting them to a non-exempt employee. So that's just a heads up on that. Some other wage and hour issues are off the clock work. This is a real risk with remote work. So what I mean by that is, when people are working remotely, you want to make sure that you've got a good timekeeping system in place. Maybe you have software to track time. For your non-exempt employees, that means, off the clock work means no working before or after scheduled hours, because if they're reading and responding to emails and text messages during non-scheduled hours, that's work time. And you may end up in a situation where you have to pay overtime. So you want to make sure you have policies, good policies about timekeeping, good policies about overtime pay and not allowing overtime without advance permission from supervisors, that you've trained both your managers and your employees about not allowing off-the-clock work, etc. There's also questions about whether, if you have an organization where people have to wait online in order to get their temperature checked before they come into the office, or do an employee questionnaire or have a COVID-19 test, is that time compensable while they're waiting online to, to start work? And so it's a little unclear at this time. Different jurisdictions may take different views, but the more conservative approach is that you just pay your employees for that period of time that they're waiting to go through the health screening. You also have obligations under federal law and state laws as well, to keep records of time for your employees. So make sure that you are, you're complying with those laws. And retaliating against somebody for complaining about their wages is also a violation of the law. So you want to be mindful of that. Another thing to just be aware of, if you are planning to do salary reductions, other things, that if you have an employment contract with your employees, take a look at what that says, because that could impact both the severance issues, your ability to reduce salary. If there's a collective bargaining agreement, that may have terms with respect to recall or bumping rights, seniority. So that's important to take a look at as well. As I mentioned, certain states may require you to provide notice before you make any type of salary reduction. Be aware that your employees may be able to collect unemployment if you're reducing hours, depending on how much you're reducing their hours, or if you're furloughing them. There could be benefits issues that are implicated when you reduce salary, meaning that employee who was eligible for benefits now is no longer eligible. So you want to take a look at your benefit plans before you're making these changes and understand how it's going to impact your employees, and and you'll inform them of those changes. And there could also be certain immigration issues with respect to employees that you have on visas who either can't have their salaries reduced, or there could be other issues with respect to the particular visa that they have that will have a bearing on, or may have a bearing on decisions you make and whether or not they can continue to work for you. So make sure that your decisions are complying with the federal and state laws. If you have employees on furlough, you want to make sure that you can continue their health insurance benefits, if that's the purpose of keeping them on furlough, and if so, for how long. So you may need to speak with the health insurance company. You may need to consider whether you have to amend your benefit plan. So review whatever agreements that you have and benefit plans before you're going to decide to make some significant change like furlough, layoff, salary reduction, etc. I'm going to speak just very briefly about WARN. It's a complex law, and your state may have its own mini WARN statute that imposes greater burdens on you as an employer. But essentially what it is, it's a federal law. WARN stands for Worker Adjustment and Retraining Notification Act. If you are an employer of a certain size, the federal law is employers with 100 or more employees to provide advance notice to employees or their representatives, where you have a union, the state dislocated worker units, and the local chief elected government official, where there's a plant closing or a mass layoff that results in an employment loss to at least 50 full-time employees, or a layoff of 500 or more, where the layoff or furlough, let's say, is going to last more than 6 months. There are certain exceptions where the notice period can be shortened, like unforeseeable business circumstances. But I just want to alert you to the fact that there is this law, that your state may also have laws relating to this, even where it's affecting fewer than 100 employees. So this is important to just be aware of. If we're going to do, if there's going to be some type of employment loss, if we're going to be reducing hours, if we're going to be closing operations, if we're going to be laying off, doing a mass layoff, are there notification requirements that we need to abide by? And it's important because the penalties can be very steep. You can have 60 days of back pay that you have to pay if you don't provide adequate notice to your employees. So that's important. Remote work, I want to just quickly touch on some of the legal risks with respect to that. I did touch on some of them earlier. So the wage and hour obligations, we talked about that. Make sure you have a good timekeeping system, that you have policies, that you've issued those to your remote work employees. You may want to consider, you should definitely have a remote work policy that addresses what the expectations are. You might want to consider even having an agreement that you sign with your employees about remote work, about, you know, things like when you expect them to be available, for video conferences, when you expect to be able to, you know, that you'll know that they're going to be at their, you know, their home workstation and can be reached. You know, an agreement about them keeping a particular area of their home safe from any types of obstacles, so you don't end up with a workers' comp claim where they trip over something at, you know, near their workstation. Different kinds of things, you know, how you're going to handle, are you going to be providing subsidies for internet usage, for phone usage? Will you be providing, you know, reimbursement for any types of expenses? Just what the expectations are around that, and particularly and really critically, the issue of data security. We all know, you've probably heard in the news that the incidents of hacking and phishing scams have increased dramatically during this period, with more people working remotely. There's a much greater data breach risk with having employees work remotely, where they may be working on systems that are not secure, where they may be you know, sending things to personal email or personal files, or rather than going through, let's say, a VPN system. So there are a whole variety of data breach issues. This should be really a big focus for you in terms of this is a high risk area. You want to make sure not only that you have cybersecurity insurance that adequately covers your organization, but that you have policies in place. Certain states like New York actually require you to go through certain protocols and have somebody designated to deal with data breach issues where you're dealing with information of New York residents, and other states may also have certain things that you need to do. So you want to have data security protocols. You want to make sure your employees are educated, that you know, how often are you doing training for your employees to avoid a phishing, you know, phishing incident? Do you send out test emails to your employees every so often to see whether they mistakenly click on a link that they shouldn't have clicked on, that then could potentially expose your system to, you know, ransomware or phishing attack? So this is a really important thing, particularly if you have remote employees working. You want to deal with, are they keeping your information confidential, both in their workspace at home? That's something else you address in your remote policy or agreement with the employee. You know, what types of data security protocols are they agreeing to? Are they agreeing that they're not going to sit down with their laptop in a cafe, that they will only work, you know, on secured connections, or only work from home? Are you requiring certain things to be put in place on their laptops in terms of screensavers and other things, so if they happen to be in public, that information is not visible? So you really, really want to think about what data security measures you put in place, because this is a big legal risk for you with remote work. You want to know whether your workers' compensation policy is going to cover your remote workers. There may be payroll tax issues with employees now working in different states for an extended period of time than where your operations are based. You'll have mandatory labor postings that you still have to get to your employees even though they're working remotely. And sexual harassment is still a concern in the remote workplace. Sexual harassment can still happen in the remote workplace. So you want to make sure that you're continuing to do your trainings on sex harassment prevention, reissuing your policies to remind your employees about it. We talked about wage and hour issues with respect to remote work and the kinds of things you can do to help mitigate that risk. Make sure you're tracking the time worked and also, you know, breaks that are taken. So we talked about all of these things now. And so the last thing I want to say about sexual harassment is the EOC convened a task force a few years ago where they looked at what kinds of workplaces have a higher risk of having a sexual harassment claim. And they came up with a bunch of different categories of workplaces they had identified that pose higher risk of these kinds of claims. And one of them was decentralized workplaces, or isolated or remote workplaces, workplaces where alcohol is served. Those were three of the several different high risk categories. And so I mention this because what you have with remote work is, right, you've got a decentralized workplace, you have an isolated workplace where people are kind of working on their own, where they're not closely monitored, where you may not know about their interactions necessarily with other coworkers, where they're emailing and texting, where you have Zoom calls, and people are maybe a lot more casual than they ordinarily would be in the workplace. And the danger is that they think because they're, working from home, that means that they can loosen the workplace, their workplace behavior, or you're having an employee virtual happy hour and people are drinking and they're less inhibited and they're saying things that really are not workplace appropriate. So those are some of the risks, and those risks are real, and you just want to remind employees about your policies and continue to do your training. And make sure your employees know about your complaint procedures. So you reissue your policies even though your employees are working remotely. You do that and you have opportunities for employees to connect with one another. Okay, so we talked about that. We talked about data breach, cybersecurity. I will mention something briefly about employee privacy. You may have heard that there are mobile apps that have been developed to address contact tracing, so that will help employers to more easily identify if someone's been, if somebody has the illness or other people have been exposed. It may help track those folks. So you really want to be aware that your state could have particular laws around employee privacy. If you decide that you're going to use mobile apps, you really need to do a deep dive and find out what kind of information does this app collect? How is it being collected? How will this impact our employees? Do the employees know what information is being collected? How will this information be used that's being collected on the app? Is this app something that we are putting on a phone that we've issued, that our company has issued, or is it on a personal phone of the employee? Because that may also be a factor of difference, right? You may have a policy that allows you to monitor employees' use of your electronic equipment. That may be the case if you have an app on your phone that you've provided to them, but it may be an entirely different situation if it's their own phone. So those are things to be aware of. Insurance coverage, make sure that you've got coverage for cybersecurity and data breaches. That it's really big risk, and there being increases in D&O policy costs as a result of just greater potential exposure to legal claims. So we talked about you want to make sure that you're looking at, if you have collective bargaining agreements, do those govern any of the issues that you are going to be implementing? Do you need to collectively bargain over any safety practices that you plan to implement, or the introduction of these mobile apps? If that's something you're planning, think about how does that impact if you have a unionized workforce, what we need to do. Do we need to collectively bargain over these issues? What are the potential liabilities for injuries to clients for people that come on site? I think to the extent that you are implementing safety protocols that take into consideration both not just your employees, but also people who come on site, the more you can do to implement and enact and enforce those safety protocols, I think the lower risk, legal risk that you may have to a claim of a gross negligence. Some employers or some entities think about whether they want to implement waivers with respect to people who are coming on premises. Whether those are enforceable, as I said, is going to be an open question. Things are different in each state in terms of whether there's going to be liability immunity or not. Some states may not recognize a waiver in any event if you give that to a client. But it's also, you want to consider whether or not that's even something that you want to do. Be aware that certain states have rules regarding you're not permitted to regulate an employee's off-duty conduct. So an employer may be concerned that their employees are not being safe outside the workplace and not social distancing, and that behavior is now going to negatively impact their other employees. Need to be really careful about taking any steps against that employee who they feel is unsafe, because many states have laws that protect employees and say an employer may not discriminate against them or treat them unfairly because of their lawful off-duty conduct. And then I just want to say, separate and apart from all the legal risks that we've talked about, is just the reputational risk, as I had mentioned before, and that's really something to think about. How is this going to impact our reputation if we don't take steps to protect our employees? So to just summarize briefly, implement the types of plans that we talked about, the infectious disease control plans, conduct a risk assessment of both the job positions, tasks, and your work areas, implement your safety and social distancing plans, provide face coverings for everyone, think about whether you need to reconfigure your workspace, have a business continuity plan. If we know anything now, it's you may reopen today and have to close tomorrow. So what's your plan? Have a plan for what's going to happen if you reopen and then the conditions worsen and you need to close your space again. How are you going to service your clients? What are you going to do if we have successive waves, and plan for those? Think about, are there new ways that we can offer services to clients? I think of the telemedicine example, just your services being offered in a different way or a new way. How can we leverage technology as you are now with video conferencing and other things to help us adapt in this situation? How can we communicate more with our staff and our clients about what's happening, even if the update is we don't have a plan right now to move back into our space? That's the update this week. Also think about, I talked about safety of your workspace, but before you get into your workspace, what is your building doing? If you're a tenant in the building, what's your building doing to make sure that the tenants are safe? Have they enacted social distancing in the elevators? Are they taking temperatures of the tenants before they come in? What are they doing about the restrooms? Have they created social distancing? Have they reduced occupancy in the restrooms? So you want to check with your building management about what steps they're taking to keep the tenants safe, and communicate that to your staff and also to your clients. If there are going to be some protocols in place, you want to give those clients a heads up. Here's what to expect when you come to our building. Think about either you restricting, limiting, or stopping business travel for now, until and unless you know that things are going to be safe for your employee to the place that they're traveling to. So those are some things that you may want to consider. Update your policies, update your training, make sure your managers are trained on employee rights under the paid sick leave laws and any type of state emergency paid leave laws, on wage and hour compliance so that you don't have non-exempt employees working off the clock if they're working remotely. Refresh your harassment prevention training, make sure it touches on some of the issues that we've talked about, including preventing harassment of Asian employees, and that you are also doing your anti-harassment training is going to include sexual harassment, of course, and preventing retaliation. Make sure also, in terms of face coverings and things like that, that you're actually instructing employees on the proper use of face coverings. We see a lot of people in New York, they have masks, but the masks are on their chin or they're on their necks or something like that. That's not going to help. That's not going to help your employees as part of your safety plan if they're not wearing the masks in the way that they're intended to be used. Really important that your managers know how to handle requests for reasonable accommodation. So good to train your managers about those types of things. Think about whether you need to cross-train employees on different functions, not just if you're restructuring or downsizing, but in the event that you have employees who are going to be, who become ill with COVID-19, you want to make sure that you've got staff who's going to be able to step in and help. We talked about data security protocols, reviewing various agreements that may impact decisions to reduce salary, et cetera. If you're doing self-audits, do so with your legal counsel to preserve any privilege and address, the negative impact of any furloughs. Follow the guidance, CDC, state, regional guidance. We talked about updating job descriptions, review OSHA and workers' comp reporting requirements. I told you that OSHA may now have some reporting requirements with COVID-related illnesses. We talked about clear mechanisms for safety and health and training against retaliation. Document. One of the most important things you can do to help mitigate legal risk is document the reasons that you're taking certain actions and your efforts to address safety and health issues. We talked about that there are mandatory labor postings. You still have to provide those to your remote workers as well. And you may want to put up, in your workplace, certain safety and hygiene posters about covering your cough and things like that. Understand what laws apply and the interplay between federal, state, and local laws. Confer with your employment counsel because these, things are changing. Things are very fluid right now. And confer with employee benefits counsel on any benefits issues that may be impacted, and with immigration counsel on with respect to employees who may have visas that are working here, that could what the impact could be with respect to certain changes you're expecting to make. We talked about looking to new ways to service your clients, a business continuity plan, whether there needs to be restructuring and how you're going to use technology. Communicate, think about how you can support your employees with mental health resources, financial resources, just what are the ways in which you can support your employees. It's been a very trying time for a lot of people, and your employees knowing that you're there, that safety is a primary concern, that you want to keep them safe and you want to support them will go a long way. So thank you, and I'm happy to take any questions you may have.
All right, thank you, Lisa. So we are going to open it up to the audience for questions. So please submit any questions through the Q&A tab at the bottom of your screen. And we have a few to get you started. Okay, so if there's any that you just don't feel are appropriate to answer, we can follow up afterwards. So what if an employee does not want to go back to work in the office because of risks in commuting, such as taking the train or bus, but is willing to continue working remotely?
Yeah, so that's a common question that I've gotten about this concern about traveling to work and not knowing whether it's going to be safe to work. This is, again, that question is going to be, what is the is it simply just a generalized fear, or does this person have an underlying medical condition that would require you to reasonably accommodate them? So I think that the employer is going to need to ask more questions about what's the reason. Is it a generalized fear of traveling on the subway, in which case there's not going to be a legal obligation? Or is there an underlying medical condition, in which case there may be a need to reasonably accommodate that person, and then thinking about what can that reasonable accommodation be. It may not be that the person works remotely. Maybe the employer is providing another means for that employee to get to work. Maybe that employer is staggering that employee's work time so that employee is not traveling during rush hour. So it's really going to depend on the particular situation about what the employer needs to do. And I think also kind of one of the themes that I've said about employers being flexible and coming up with creative solutions so that their employees do feel safe and supported is really important. So even if you may not have a legal obligation to do something, you may still want to figure out a solution that works for both you and your employee.
Okay, thank you.
Mm-hmm.
What if an employee is simply scared to return with no underlying condition? If we don't know about underlying conditions, are we allowed to ask for the purposes of reasonable accommodation? And we have a situation of a very small office, and the three women over ages 55 are in, and the 27-year-old is refusing to come to work or do site visits, quote unquote, until a vaccine is given.
Mm-hmm. Yeah, well, okay, so I come back to, is there a legal obligation? So a generalized fear generally of coming to work is not going to suffice as an excuse for not coming. However, I say that with the caveat of the things I've discussed before, which is if the person has good faith safety concerns because of something the employer hasn't done, that they know that this employer has created an unsafe condition, that may change, you know, the answer about how you deal with this. But generally, a generalized fear of just a generalized fear is not going to be sufficient as a reason to not report to the workplace. And what I would also say to that is that the employer should do everything in their power to make clear to the employee the steps the employer is taking to keep this workplace safe. Here are the safety protocols. Here's what we're doing. We're going to have face coverings for you, and we're going to have gloves, and we're going to have hand sanitizer stations, and we have a cleaning company who's come in to disinfect before everybody's coming back to the workplace. This company is going to come and disinfect every so, whatever the situation is. Do things that reflect that you've taken the steps that need to be taken. Certainly if your state is requiring a safety plan, that you've done those things to reassure employees we're creating a safe space for you to come to work. So.
Okay. Thank you. Mm-hmm. Another question says, our building is old and not well ventilated. Also does not have hot water. I have heard prolonged breathing of air across the room can increase exposure greatly, even when mask and social distancing is in place. This is largely why we have not yet reopened. Do you have any insight on this?
I don't have any insight on that particular situation. I'm not sure also if the building is a building where your organization is a tenant, but, and while I can't give legal advice, what I would say generally is that if you're a tenant in a building, to confer with the building management company to find out are they doing anything to increase the ventilation in the building? What are they doing? What are they doing? Are they putting in certain kinds of HEPA filters that filter out for COVID-19? What are they doing? What are they doing generally in terms of increased ventilation? And I think as an employer, the employer needs to make a determination about what the building is doing, if anything, and whether the employer believes that the space is going to be safe for the employees to return. So I think that's an important assessment that the employer is going to need to make, but I would say make an initial inquiry of the building management and check your lease also to see if you have certain protections under your lease in terms of what the building management is required to do to make the space, one that you can safely occupy.
Okay, great. And then I know, Lisa, you are going to be sending out a resource for everyone, an article, I believe, on the Perlman and Perlman website. But someone asked if you have links for the CDC or any other helpful resources that you can share.
Yes, actually, at the end of this presentation, I have some resource pages, and that will have not just some articles, that I've written recently, but we also have, you can scroll through them at your leisure, different things like the CDC guidance for business reopening, reopening decision tree that the CDC put out, the some of the OSHA guidance that I've mentioned to you. There's guidance on reopening building water systems. One of the risks related to this whole situation is where you've had a building that's, systems have been shut down for a while, there could be an increased risk of Legionnaire's disease. So the CDC also has some guidance about that. Employers may want to ask their building management company what kind of mitigation efforts the building's taken to mitigate the risk of Legionnaire's disease. So anyway, yes, in answer to your question, I have a bunch of different resources at the end of the presentation that should be helpful. Places for you to go to, to help guide you as you do your safety protocols. We can be of assistance in any way with this as you are preparing your safety protocols or policies or anything. Please feel free to reach out to me directly. So is there any other questions, Kim?
Yeah, there are just two more. So a follow-up question to the contract tracing you had spoken on was, so the employer cannot perform contact tracing within the office. It was
okay, go ahead.
No, she was just trying to verify that that's what you had said.
No, I didn't say that. What I said was that
Okay.
the employer may not tell other employees who has COVID-19. So if an employee gets ill with COVID-19, the employer may not disclose to those employees the identity of the employee who's sick. However, the employer should definitely inform employees who have been exposed or may have been exposed to that employee that they may have been exposed and should get tested for COVID-19. That's very important that employers absolutely, as soon as they know, inform their employees who may have been exposed that they may have been exposed. That's really, really crucial for employers to do. And employers may tell state and local public health authorities the identity of that employee who is ill. And the reason for that is that the state and local public health authorities have an interest in ensuring that the illness doesn't spread. So they may need to follow up with that employee or that individual to find out who else they have recently been in contact with so that they can contain the spread. So I hope that clarifies the contact tracing issue.
Okay. And last, couple more questions. Once there is a vaccine and the threat of COVID-19 is at a minimum, can you determine a date when all employees must return to work? Can you require healthy employees and employees with children to return and older employees?
Once there's a vaccine, one of the questions that kind of remains open is that the EOC was asked about is once there's a mandatory vaccine, can you require that employees show you that they've been vaccinated? The EOC says they're working on that, and they'll address that soon enough. I think, again, the question will always remain, and sometimes there are medical reasons why someone can't have a vaccine. So I think that really what you'll need to do is at the time of that situation, if somebody has an underlying medical condition, that person may still need to be reasonably accommodated. And I think you're going to have to engage in an individualized assessment with that person to determine a reasonable accommodation that allows them to perform the essential functions of the job. And you know, as I said, the reasonable accommodation could be remote work, but it could also be an accommodation that allows them to socially distance in a way that they're not going to be exposed. So, if somebody has a disability, employer has a duty to reasonably accommodate them. So I hope that answers the question with respect to people with an underlying health condition. And, you know, there may be either religious objections or medical reasons why someone may not be able to, get a vaccine. So we have to, I think we have to see what happens with that situation.
Okay, and last question is there any protocol for taking employee temperatures on a daily basis? Can any colleague perform it, or must it be a third party?
I don't think it needs to be a third party to conduct the temperatures. I think what has been said by OSHA and other agencies and certain, I can say like local anti-discrimination agencies, for instance, like the New York City Commission on Human Rights, is that if you're doing a COVID-19 test, you want to make sure that whoever is conducting that test, well, first of all, you were just asking about temperature. So in answer to your question about temperature, I think, someone in the workplace, whether, it's your HR person, can conduct the temperature taking. They have these devices that you can scan over someone's forehead. OSHA has some other rules around conducting tests and things like that.
Great, thank you. So that looks like all the questions we have. So we're going to wrap this up now. Thank you for joining JMT Consulting and Lisa Brauner for this webinar today. I'd like to thank you, Lisa, for your time, and we hope you all enjoyed the presentation. You will receive an email from JMT Consulting within 24 hours with the recordings, the slides, and Lisa's contact information should you want to reach out. And we would also love for you to join us at future events and webinars, which you can find listed on our website, jmtconsulting.com, and clicking the Training and Events tab. So this will conclude the webinar, and I hope you all have a great day. Thank you, Lisa.
You're welcome. Pleasure.